Hi everybody, welcome to the Arts and Humanities Faculty Research Series 2021 on After Brexit, Utopia and Dystopia. I'm Hussein Kassim, I'm Professor of Politics at UEA and Senior Fellow of the UK Interchange Europe. I'm also the convener of this series. These fortnightly events have enabled us to hear leading figures discuss their views about the future, the role the UK should play in the world, the UK's relations with the rest of Europe, and whether global Britain is a realistic vision. And it's also enabled us to put our questions directly to them. I'm delighted to welcome you to our fifth event. In previous weeks, we've heard from Daniel Hannan, from John Bruton, from Margaret Macmillan, from Nicola McEwen, Dan Wincott and David Finnemore. Tonight, I have the very great pleasure of introducing Dominic Grieve QC PC. Dominic is a British barrister and former Conservative politician. He was Member of Parliament for Beaconsfield between 1997 and 2019, and he served as Shadow Home Secretary from 2008 till 2009, then as Attorney General for England and Wales from 2010 to 2014. He campaigned against leave, he strongly opposed the no-deal Brexit, and he sought after Theresa May had resigned the Conservative Party leadership to prevent the prorogation of Parliament by Boris Johnson. He's an active member of the European movement. The title of Dominic's talk is Brexit, Revolution Without End or a Stable Future. Dominic, it's a great pleasure to welcome you this evening.
Thank you, Hussein, and thank you very much for your welcome. And thank you for inviting me to give this talk. I'm sorry that COVID prevents me being present in person. I hope, however, I can do justice to the topic virtually and add my own thoughts as a lawyer and as an ex-politician, the best way to describe myself, to the series that you have been holding. For all the talk by the Prime Minister of getting Brexit done at the 2019 election, I think the one thing which both ex-leavers and ex-remainers might agree is that at present the consequences of our leaving have still also left a lot of unfinished business. The 5 years that have followed the 2016 referendum have been a time of political and constitutional upheaval. The present government obtained the mandate to carry a hard Brexit through in the 2019 election, but now has to deal with its aftermath and set a new path for our country, with the extra problems caused by COVID, both amplifying some and masking other of Brexit's effects. Now, in voting to leave, the EU, the majority in its mantra of taking back control, was certainly making a demand of government and parliament for a change in direction for the United Kingdom in respect of our participation in building supranational frameworks, of which the EU was probably our most important. The referendum was also a demand concerning what's expected of our unwritten constitution, which has become heavily entwined with the supranational frameworks the United Kingdom has helped build. And I wanted this evening to look at this and look what's happened with those issues during the Brexit process, and at how revolutionary or traditional they might be, because I think they can provide a guide as to what is likely to happen next. Although, I should emphasize, certainty as to the future is never possible. We shouldn't be surprised at Brexit producing problems. Our participation in the EU for 46 years was a process of major legal and constitutional change. 1971, that Edward Heath as PM secured the support of resolutions in both the Commons and the Lords for the UK to join the then EC. A year later, that the domestic legislation giving effect to our agreement to join was incorporated into our domestic law in the European Communities, infamous or famous European Communities Act 1972, giving primacy to EC law in our country. Parliament of the United Kingdom decided in furtherance of a treaty of accession that it believed it was in our national interest to allow the Court of Justice of the EEC to override UK statute law in certain very specific purposes to ensure conformity with EC law in those areas where the EEC had competence. Now, following that accession and the 75 referendum, which started off my political career, maybe I went in the wrong direction from the outset. There were then some 20 further treaties as our involvement deepened. And as the creators of the EEC and the EU, its successor, have been concerned that EU law should operate fairly within its areas of competence and not abusively, should uphold democracy, rule of law, principles reflected in the European Convention on Human Rights, as well as other international treaties on social and economic rights to which all EU members are signatories. The scope of the treaties was extended through the Charter of Fundamental Rights to confer some personal rights for EU citizens directly enforceable in national courts. Finally, in this short list, quick survey, the Treaty of Lisbon brought in the Article 50 provision, allowing a state to withdraw from the treaties on giving 2 years' notice. But the truth is that despite the Article 50 process being available as a broad guide as to how one might leave the EU, it was a feature of the 2016 referendum, but no consideration whatever had been given beforehand as to how the UK might in practice extract itself from such a deep legal and economic involvement. And I think that much of what's followed comes from this decision to ignore the possible consequences of leave vote until after it had happened. And I have to say, as an ex-Remainer, I remain of the view that when we debated it in the 2016 referendum, many people would not have appreciated some of the surrounding issues. Equally, some people were doubtless very determined to leave, whatever those issues might be. I think the other thing I would like to just mention and touch on before we go into post-referendum events is it's important to understand that the UK, which left the EU in 2016, was quite irrespective of the EU, a very different place from the country that joined it in 1973. When I was reading for the bar in the late 70s, constitutional and administrative law was a bit of a sideline. I remember being taught about the principles of parliamentary sovereignty. Queen in Parliament, acting with the consent of her Lords and Commons, exercises power unlimited by any other lawful authority. In practice, that means that the Prime Minister can enact statutes with the approval of Parliament that can change the law and sanction administrative acts without legal limit. That was the product of the conflict between the Crown and Parliament in the 17th century, the overthrow of King James II in the Glorious Revolution of 1688, and the enactment of the Bill of Rights of 1688 or 89, which in its 13 clauses limited the power of monarchs to act without Parliament's approval. In particular, I remember Clause 9 being emphasised, principle that the actions of Parliament can't be impugned in any court, and that the will of Parliament is expressed in statutes passed by Parliament and given royal assent, is open to interpretation, but cannot be contradicted or overturned. Also, another strand that ran back to Magna Carta in 2015, and I think was interwoven with the first. And that suggested that although the Crown in Parliament might enjoy unlimited power, there were constitutional markers that this power had to be used within certain limits. The Charter, of course, predates Parliament's. It originates in a desire to curb the power of medieval monarchs to raise money by arbitrary fines and levies. But the two clauses that have survived to modern times, 39 and 40, prohibition of punishment without due process of law and the promise not to delay or deprive a person of justice, are still defined as the arbitrary, as defining statements of the rule of law and the limits of arbitrary state power. Now, those principles, often violated, in fact, by medieval and Tudor monarchs, despite what it said in paper, are part of the subtext of that conflict in the 17th century. 60 years before the Bill of Rights, Sir Edward Coke, the great jurist of the common law and Chief Justice under James I, defied the king and argued that his sovereignty was limited by rules of natural law and not just by the need to govern through Parliament. In the case of proclamations of 1611, he asserted and finally established that the king cannot change any part of the common law nor create any offence by his proclamation, which was not an offence before without Parliament. The king has no prerogative but that which the law of the land allows him. And those two statements, as we will see in a moment, played a major role in the two Miller cases in the Supreme Court post-Brexit, and interestingly, in the continuing talk of the government today in seeking to, as they would say, curb judicial power in its irritation with the judiciary's input during the Brexit process itself. Now today, in contrast, much has changed. What's brought it about? Several drivers which have actually very little to do with the EU. The first perhaps not the most obvious. It concerns the extent to which we're no longer governed by statutes passed by Parliament, but by subordinate legislation. 1950, there were 28 statutory instruments passed by Parliament. 1966, 71. 72, the year we entered the common market, so there is a link to it, 1,100. At present, it's around 1,500 a year, although it's peaked at 3,500, and it's not going to come down as a result of leaving the EU. Most are never considered by Parliament, although, as we've seen during COVID. Yet each is a use of executive power that is amenable in theory to review by the courts and can have a profound impact on the lives of citizens, as indeed COVID is showing us. So we should perhaps not be surprised that in its wake, the number of judicial reviews has grown exponentially, as well as administrative decisions made under these statutory instruments that have been challenged for illegality, unfairness procedurally, and irrationality. 3,500 such claims approximately in 2018. But insofar as this has fueled criticism by politicians of judicial interference in the work of the executive, they ought perhaps to ask themselves the question as to how this has happened and what the consequences would be if all these statutory instruments couldn't in fact be looked at by courts. Leaving the EU is not going to make a difference. Second one, our adherence to the European Convention on Human Rights. We helped draft that in the 1940s as a consequence of the Nuremberg trials and what happened in the Second World War, to give aspiration to the United Nations Charter and make some possibility of implementation in practice. 1960, we bound ourselves to observe its decisions. 1966, we were one of the leading advocates of allowing the right of individual petition to the court. Once that came in, it's allowed a growing flow of cases to the court, which has nothing to do with the EU, and a series of landmark cases challenged and halted practices which were once considered acceptable in Western democracies, but which would now be seen as entirely unacceptable by the vast majority of the public, including giving a small jolt to perhaps a little bit of United Kingdom complacency, such as over Ireland and the UK in 1978 on British interrogation techniques used in Northern Ireland during the Troubles, or Dudgeon and the UK in 1981 on the continuing criminalisation of homosexual acts in private in Northern Ireland. The volume of cases going to Strasbourg, which led in part to the decision of the Labour government of Tony Blair to bring in the Human Rights Act, that allows claims under the European Convention on Human Rights to be brought in domestic courts for our own senior courts to interpret the meaning of the articles of the Convention, guided but not bound by the jurisprudence of the Strasbourg Court. It can lead to the strike down of statutory instruments and declarations of incompatibility for primary legislation, which is controversial. Lord Sumption, in his Reith lectures, and also actually before he went to the Supreme Court, raised his concerns that the Human Rights Act has shifted the boundaries between political and legal decision-making. This is because when judges are making decisions involving qualified convention rights, the determination nearly always involves striking a difficult balance between competing public interests. So it makes some Home Secretaries angry, with the opinion being expressed by some ministers today that they should only be answerable to Parliament and they shouldn't be answerable to courts for these decisions. Some want it repealed, the Human Rights Act. Some want us to leave the European Convention. I rather doubt this will happen. A return to pre-ECHR days would quickly expose a lack of redress for issues widely regarded as injustices, and that we would have no mechanism then to remedy. Finally, in this list, take it at a bit of a canter, is devolution. Prior to it, the United Kingdom, outside at least in theory of Northern Ireland, was governed as a centralised unitary state by ministers answerable solely to the Westminster Parliament. The penny hasn't yet dropped with some people of the extent of the change, then what's happened over COVID has clearly shown that this is no longer the case. In setting up devolution, Parliament gave to the Supreme Court the role of arbiter of the interpretation of its limits. The Supreme Court on occasion had to do just that, When I was Attorney General in 2013, I appeared on behalf of the then Conservative government, or I suppose coalition government, in the Supreme Court, which had to decide whether a Welsh Assembly decision to keep an agricultural wages board, which was being abolished in England, whether that concerned agriculture, which was devolved, or employment law, which was not. And despite the fact that when the 2006 Devolution Act was passed, civil servants in both London and Cardiff had both agreed to treat the wages board as being part of employment law, the Supreme Court held that on statutory interpretation, it concerned agriculture. So I lost the case. The UK government could, of course, use the UK Parliament to reverse that. But politically, that's often not going to be possible. So here again is an area of judicial growth in constitutional matters and a great change in the way the United Kingdom is governed. And the devolved administrations are, of course, entirely bound for their primary legislation by the Human Rights Act, which actually can give rise to the quashing of their own statutes on that ground, something which is regarded as unthinkable in the context of the Westminster Parliament. Now, these issues of governance are in fact and were all in focus as the government has worked to remove us from the EU. First big legal question, how do you trigger Article 50? Government took the view that as the original adherence to the EEC had been by treaty through an exercise of the royal prerogative, in treaty making backed by a resolution of both houses of Parliament, it could trigger Article 50 as an exercise of the royal prerogative and no statutory authorization was needed. It could also, fairness to it, highlight that nothing in the 1972 Act excluded the use of the prerogative power to negotiate and adhere to treaties in respect of the EEC. Mrs. Gina Miller disagreed on the grounds that as leaving the EU had a massive impact on the statutory rights conferred on UK citizens during the course of and through EU membership, then removing these by withdrawal from a treaty triggered by a prerogative act was outside the scope of prerogative powers. Counter to that principle enunciated by Sir Edward Coke in the case of proclamations of 1610, we tend to go back a long way in this country. The king by proclamation or other ways cannot change any part of the common law or statute law or the customs of the realm. Her challenge was also joined by the devolved administrations in Scotland and Wales, arguing that Brexit required the consent of their legislatures to be carried out. The court's majority view was that the 72 Act effectively constituted EU law as an entirely new and overriding source of domestic law, and that there were rights which were freestanding under EU law, which were not required by EU membership, such as the right of UK citizens to vote for election of MEPs. And these could not be removed, and removing those without statutory authorization was improper. So they concluded that you needed a statute. The court was also unanimous that the devolved administrations didn't have a veto over leaving the EU. And that doesn't come as a surprise. If they had, it would have implied that the devolved administrations had an effective veto over UK foreign affairs, which was quite clearly outside of their competence. The fascinating thing about the case, as far as I was concerned at the time, was that this was really a pretty esoteric point of law. I'm not even sure that the case was really necessary, because as everybody found out, virtually all Conservative MPs, with I think the sole exception of Kenneth Clarke, voted to trigger Article 50. I did, because I had committed myself to triggering it as a consequence of the outcome of the referendum. But a glance at the headlines which followed might not have left one with that impression. The High Court and the Supreme Court were vilified, or the judiciary in them were vilified, by the national newspapers, two of the national newspapers, the Telegraph and the Mail, or I think the Express probably also joined in, of a kind that one might expect of a country sliding into tyranny. The then Lord Chancellor Liz Truss, I'm afraid, disgraced herself by her failure to stand up for the judges against the tone of the attacks. The idea was promoted the judiciary were thwarting the will of the people, a sound that continues to echo today, in which the present government has done little to discourage. The irony is that the judgment, in fact, gave some framework to the government's approach where none had previously existed. The next problem which illustrates, I think, the revolutionary aspect of Brexit, was that the government itself didn't actually know what was needed by way of legislation to carry it out. Indeed, it didn't really know what it wanted to do or from Brexit, what it wanted to get from Brexit itself. It brought in the EU withdrawal bill and called it a Great Repeal Bill, which of course sounds very good for those wanting to throw off the European yoke. But of course, the bill was nothing of the kind. On the contrary, it was intended to entrench and convert EU law into domestic law to avoid our falling into a void of lawlessness on the first day after our departure. Just to give an idea of how big a void that was, EU membership involved 40,000 legal acts, 15,000 court verdicts, and 62,000 international standards, binding on citizens and companies in the UK by virtue of our EU membership. The bill, now an act, which kicked in at the end of transition on 1/1/2021, is a monster of a piece of legislation, although most people seem to have virtually forgotten it exists. It takes EU law, but rather than retain it as a block, it then seeks to discard elements of it which don't seek to suit the government's political agenda. The key thing to understand is that the legislation reduced both the Charter and general principles of EU law to no more than interpretative aids. The protective rights which were previously there to ensure that EU law could not be operated abusively disappear, leaving only the possibility of a challenge under the Human Rights Act. The justification for this was, of course, that it would be wrong as we were leaving the EU to allow any element of judicial supremacy inherent in the way EU law operates to survive, because it offends parliamentary sovereignty. The alternative, allowing our own Supreme Court to do that role, was rejected. But of course, one could argue that the sorts of laws we were dealing with would never have been enacted if there had not been a judicial safeguard with respect to their interpretation to prevent anomalies and correct them. And that has created something very odd. One of the main complaints about EU law is it's either forced on Parliament, which then had to enact it, or worse still, could in some cases be directly imposed on us from the EU. Yet to maintain predictability, we've preserved its supremacy in relation to pre-Brexit primary legislation. We're also treating all direct EU legislation as primary for the purpose of the Human Rights Act, even though an awful lot of it, except for the CAP regulations, even though a lot of it has the character of second legislation and is highly technical. It may be years before it's all replaced by domestic law. In the meantime, if you want to challenge it, if it leads to injustice or abuse of power, it will in fact be very difficult. In one of the most remarkable arrogations of power to the executive, which I think I've ever seen actually in my life, Clause 1(2)(b) of the Act leaves open the possible creation of the right to challenge retained EU law for being invalid at the date of exit, but only if the challenge is, quote, of a kind described or provided for in regulations made by a minister of the Crown. And I really can't think of any other example of an important legal right being created or denied in this fashion by executive power. The Act also had extensive Henry VIII clauses in it, which means that they provided material for altering primary legislation by secondary legislation. In fairness, they were probably needed in order to cut through the morass of the law that, in bringing about Brexit. And there were some sunset clauses. But it did mean, in theory, that important legislation as the Equality Act could be amended by this method within the permitted period. Also powers to prevent the devolved administrations from amending or any retained EU law, even if this fell within their area of competence, because otherwise it could impact on maintaining legal uniformity throughout the UK, presaging a later disagreement, which I shall come on to, in respect of the Internal Markets Bill. And then last and not least, there was an infamous Clause 9, which I think then changed into being Clause 13, which allowed the government to take us out of the EU in furtherance of any withdrawal agreement without actually having to enact any primary legislation at all. Now, my view at the time was that the complexity of the law, of the legislation, went against Lord Bingham's first principle of the rule of law. The law must be accessible and, so far as possible, intelligible, clear and predictable. And at the start of the bill, there was actually some serious disquiet by the senior judiciary that it would be incapable of interpretation, which rather suggests that the judges were hardly trying to take over. They were really worried about being landed with this. And that's why, of course, I rebelled for the first time over Brexit on this, because I considered that the powers to take us out of the EU under the withdrawal agreement without primary legislation were improper. And I was successful. I think that was later described as being a meaningful vote for the Commons at the end of the negotiating process, but in fact it wasn't. It required statutory approval of any withdrawal agreement before any of the statutory instruments provided for in the Withdrawal Act could be used to implement withdrawal. In practice, it made those powers redundant, and when eventually we did withdraw under the Withdrawal Act 2020, the whole of that section was repealed, because it was the Withdrawal Act, Agreement Act 2020, which provided the power to do it. Although it's worth pointing out, and I'll come back to it, that was hardly scrutinised by Parliament at all. The other problem is that post-Brexit, we became enmeshed in a battleground as to what the nature of our withdrawal from the EU should be. There's no doubt that a minority but significant number of Conservative MPs were determined that our exit should not be delayed or any possibility of reconsideration of Brexit take place in the event of there being no agreement reached or no agreement being reached for our departure, or that agreement being rejected by the House of Commons. So they persuaded the government to put the date of departure, the 30th of March 2019, on the face of the bill, so it would need primary legislation to change it. And that led to another parliamentary standoff in the middle of 2018, with a pretty pointless one in my experience, at the end of which it was agreed that the date could be changed by statutory instrument and wouldn't require a further piece of primary legislation. There were also debates as to what would happen if Parliament didn't agree a deal and how you should sequence votes thereafter to try and reach some sort of solution. And then finally, in this consideration of the Withdrawal Act, there was the devolution element in it. The bill was amended to try to meet some of the objections of the Welsh, of the Scottish, Northern Ireland and Welsh governments. And ultimately, the Welsh government supported it. But it still remained a very serious issue of contention about the repatriated powers and the ability of UK ministers to freeze those powers and to proceed to do this even when there had been refusal to do that from the devolved administrations themselves. Now, all this, I gently predict, has the capacity to generate a lot of litigation in the future. It's too early for that to have happened. But more tellingly, it demonstrates that when faced with a complex problem, cutting through it soon becomes more important than respecting the constitutional principles which Brexit was actually supposed to be reasserting. So, as Brexit has proceeded, we've had the paradox that a change being carried out in the name of tradition has actually been done in a fashion that a constitutional traditionalist would be absolutely horrified by. The government of Theresa May strove, of course, to reach a deal with the EU, but the nature of that deal proved predictably divisive because of the lack of prior focus on it and the fact that any deal implies some degree of concession to EU structures and rules, which undermines the rationale for leaving in the first place. Whilst wanting to leave the single market, which Mrs. Thatcher created for the benefit of the UK, Theresa May still wanted to keep a close alignment with the EU to allow for frictionless trade in goods and close cooperation on security and foreign policy. A key issue in the negotiations was the future of Northern Ireland and the complexities of the British-Irish relationship. It was implicit in the Belfast Agreement, or Good Friday Agreement of 1998, that it depended on the shared EU citizenship across the island of Ireland, with all that implies for freedom of movement and trade. As our continued participation in the single market and the customs union was ruled out by Theresa May, It meant that in any event, special arrangements had to be made for any withdrawal agreement to guarantee the continuing functioning of the Belfast Agreement. And as Theresa May was unwilling to allow any circumstance to arise that could damage the integrity of the UK, it led to the Northern Ireland backstop or protocol being agreed that would have maintained alignment on tariffs and regulations for the whole of the UK and the EU until a time as a way could be found and negotiated to allow for divergence through an alternative agreement without the need for border checks between Northern Ireland, the Republic of Ireland, and Northern Ireland and the rest of Great Britain. It was that arrangement that was fiercely denounced by some MPs, including Boris Johnson, who called it a vassalage clause. It led to his resignation and the resignation of other ministers when the outline of the withdrawal agreement became clear in July 2018, and fatally undermined her administration. The agreement as negotiated was then the subject of a fierce debate, rejected by the Commons twice in January 19 and a third time in a slightly different form at the end of March. Meanwhile, in January 2019, the Speaker reinterpreted the standing orders of the Commons to allow for votes that would allow a majority of the Commons to determine its business, removing the monopoly power to table most business from the government. Following an emergency extension of the Article 50 process by agreement from 20th of March 19 to the 12th of April, the Commons used those new powers to command the order paper and, with the consent of the Lords, enacted on the 8th of April 2019, the EU Withdrawal Act 2019, which required the government to secure a lengthy extension, which the EU duly gave to us and which expired on the 30th of October. Despite efforts to secure a compromise with her own backbenchers, Theresa May was then forced to resign. Boris Johnson became Prime Minister on the 24th of July 2019 with a promise to take the UK out of the EU, either with a new deal or with no deal at all. And it was during that campaign that I think Dominic Grieve, who's now the Foreign Secretary, first raised the possibility that the government should simply dispense with Parliament so as to force through Brexit against the obstruction of a majority of the House of Commons, which I think was a reflection of the anger of hard Brexiters at the Commons' insistence in April that the Article 50 period had to be extended, and the clear majority in the Commons who were insisting that there had to be an agreement to leave and that a no-deal departure could not be contemplated because of its consequences. Boris Johnson indicated in his leadership that he didn't agree with that draconian idea. I have to say, in the context of a modern parliamentary democracy, it was an astonishing thing for Dominic Grieve to suggest. Prorogation in recent times has only been used to bring about a short break between parliamentary sessions, or sometimes a short lengthening of general election periods. But it was the anxiety over that that led Parliament first to try to obstruct it by amending a Northern Ireland executive formation bill to require Parliament to be reported to at least 2 occasions in the autumn. It was hoped that that would prevent prorogation. And subsequently, when it became clear from leaks within the civil service, it's the truth within government, that the government was plotting to prorogue Parliament, it led to firstly, the challenge in the Court of Session that was mounted by Joanna Cherry to get a declaration that prorogation was unlawful, and the passing of the Ben-Letwin Act in early September, which was designed to ensure that an extension had to be secured if no agreement had been reached by the 19th of October. We got the Ben Act through Parliament, and that was done successfully. And as you will be aware, the challenge in the Scottish courts initially failed, but subsequently succeeded on appeal. And in the divisional court, it failed. But when the matter was sent directly to the Supreme Court, the judgment in the inner house of the Court of Session was that the advice the Prime Minister had given the Queen was justiciable. It had been motivated by the improper motive of stymieing Parliament, and that it followed from that that the prorogation was null and void. and essentially the judgment of the Supreme Court repeated that. It clarified, interestingly for our Constitution, the nature of a prerogative power, a power recognised by the common law and exercised by the Crown on advice from the Prime Minister. The fact that a dispute over it concerned the conduct of politicians and might be a matter of political controversy was not a reason for the court not to consider it. The argument that the government should be answerable to Parliament alone for its action on prorogation was rejected. Firstly, because the effect of prorogation was in practice to prevent accountability to Parliament, but in any event, because the power had to be exercised within the scope of the law on which only the courts can rule. Case of proclamations of 1611 was cited again. The king hath no prerogative but that which the law of the land allows him. The UK might have no written constitution, but that doesn't mean that none existed. A fundamental principle is that of parliamentary sovereignty, which would be undermined if Parliament could not sit to scrutinise the executive. An unlimited power of prorogation is therefore incompatible with it, and that was supported by the statutory requirements as to the sittings of Parliament in the Bill of Rights and elsewhere. The conduct of government by a Prime Minister and Cabinet, collectively responsible and accountable to Parliament, lies, the Supreme Court said, at the heart of Westminster democracy. And therefore, it followed that the relevant limit on the power to prorogue Parliament would be if the prorogation had the effect of frustrating or preventing without reasonable justification, it would prevent the ability of Parliament to carry out its constitutional functions. And the Prime Minister, the Supreme Court pointed out correctly, had been unable to show any reason, let alone a good reason, for the length of the prorogation. It's worth bearing in mind that no affidavit had been filed because, in truth, no civil servant or minister was prepared to file an affidavit which disclosed the truth about the timing and the motive of what the government was planning to do. So the court then went on to hold that the prorogation ceremony wasn't part of parliamentary proceedings and declared the entire process void. Now, in my view, this is totally different from the first Miller case. It's not an esoteric point of law at all. The government lost the prorogation case because under the impact of political crisis, it was acting in abuse of its powers. I doubt it helped their case that the threats coming out of number 10 Downing Street at the time, a Prime Minister would refuse to write the letter requesting the extension, which eventually he did do, even though I think he then wrote another letter the following day saying it should be ignored. But I think that the Commission in Brussels probably understood the UK Constitution and our laws better, perhaps, than the Prime Minister did himself. Far from being revolutionary, the actions of the Supreme Court were absolutely in line with past decisions on abuse of the prerogative. The revolutionary behaviour in all this was that of the Johnson government. So, thwarted from being able to credibly threaten or implement a no-deal Brexit, Prime Minister then completely changed course, signed a withdrawal agreement almost identical to that of Theresa May, but abandoned a UK-wide backstop for one that applied to Northern Ireland only, and thus had the inevitable consequence of creating a border down the Irish Sea between Great Britain and Northern Ireland if there was no trade agreement for frictionless trade negotiated after we had gone. Although he secured the second reading of the ratification and incorporation of the agreement into our law in late October 2019, I think the risk he saw was that the reality of the agreement would be exposed at the committee stage of the bill, which he'd been unable to guillotine. That's what made him want a general election that Jeremy Corbyn, in his folly, kindly gave him, oblivious of his own unelectability as an alternative in government for government. The Prime Minister won with a majority of 80, pushed the withdrawal agreement act through. I was no longer in Parliament then. I think in about 3 days, with virtually no scrutiny of the detail at all. The irony that the withdrawal agreement required reviving the hated 1972 Act, abolished supposedly in the Withdrawal Act, and to make it last a bit longer through transition, or that its effects in Northern Ireland are in fact going to be permanent in part, were glossed out. So we now know that things are not quite as easy as the Prime Minister suggested when he said he had an oven-baked or oven-ready deal to give to the British public. Negotiating a trade and cooperation agreement has proved difficult, both in relation to the deal itself, but also in relation to the UK government's relations with devolved administrations. We saw that with the Internal Markets Bill. The bill itself needed if the UK is to preserve an internal market with powers being repatriated from Brussels, but like the Withdrawal Act, highlights the complexities of recreating a UK single market in a post-Brexit and post-Devolution world, with the Scottish and Welsh administrations denouncing a Westminster power grab, although those powers might be largely theoretical, as they were previously exercised by Brussels. With resentment at Brexit, particularly in Scotland, now linked to separatism, it's taken on a character of conflict. Currently looks rather hard to reverse. Give some examples. There were 160 policy areas to be covered. So it's pretty extensive: food labelling, energy efficiency, support for farmers. But at the same time, the UK government required that goods and services provided from elsewhere in the UK to a different standard will have to be accepted, which is inevitable if you want to keep a single market. So if the UK government were to accept chlorine-washed chicken for England in a UK-US treaty, Scotland, Wales and Northern Ireland would have to take it even if they didn't want to. There was an office for the internal market to settle disputes, but it's merely advisory. It is the veto power of Westminster that has been made into an article of opposition by the Scottish and Welsh governments. But of course, as I say, if there's no mechanism for resolving those differences, then the single UK market would collapse with appalling consequences. Second notable feature of the Internal Markets Bill, the last-minute decision to insert new clauses that allowed the bill by statutory instrument, government by statutory instrument, to ignore the clauses of the Withdrawal Treaty concerning the maintenance of the single market with no checks between Northern Ireland and Ireland. On the basis, the Secretary of State for Northern Ireland admitted this was a breach of the UK's obligations under the withdrawal agreement. To threaten such a breach and indeed carry one out by introducing the legislation immediately breaches the requirement of good faith, both in the withdrawal agreement and the one which is implied in all treaties by virtue of Clause 27 of the Vienna Convention. And it is unprecedented, I think, in modern times for the United Kingdom to threaten to do such a thing. Just worth bearing in mind that even when we've left the EU, the United Kingdom is currently signed up to about 14,000 international treaties, of which over 800 have arbitral mechanisms to resolve disputes over interpretation. If you threaten to breach a treaty unilaterally by passing domestic legislation incompatible with it, it's massively damaging to your status as an upholder of the international rules-based system of which the United Kingdom is the primary creator. That decision, of course, to bring in those clauses prompted the resignation of the Treasury Solicitor, senior permanent lawyer in government, the resignation of the Advocate General for Scotland. It also backfired as there was a rebellion both in the Commons, but particularly in the Lords, who eventually blocked it. Even some Brexit supporters like Lord Howard, Michael Howard, were appalled at what was being done. And that does raise serious questions about the way our government is now functioning. Because the breach of the ministerial code required to even bring this legislation forward was glaring. Yet the Attorney General, Suella Fernandez, did not object to it, and indeed went to extraordinary arguments to try to justify it as acceptable based on legal opinions that were neither regarded as being either reasoned or credible by about 99% of the lawyers who looked at it. It also included a denial that the ministerial code had been breached when it plainly had been. And not only had it been breached because you have to look at the code, you can see it, but because the government in a previous court case had plainly accepted that the ministerial code applied to international law as much as domestic law. There was also an attempt in that bill to oust judicial review of the statutory instruments relating to the Northern Ireland Protocol, and that too raised constitutional issues of importance before it was abandoned. And meanwhile, the deal obtained in the Trade and Cooperation Agreement is demonstrating how far we've gone from the idea of frictionless trade. Whilst COVID plays a major role, a diminution in trade with the EU of 23% in the first quarter of 2021 is clearly bad news when compared with a fall of 0.8% with the trade we were doing with the rest of the world. As trade is the motor force of the economy, it's a serious matter. There's a lot to suggest that this has fallen disproportionately on small and medium enterprises, long regarded as the motor force of our economy. And I might add that as SMEs are very prominent in a constituency like Chesham and Amersham, which is a motor force constituency of the generation of wealth in the United Kingdom, I'm not surprised that, amongst other reasons, that the electorate of Chesham and Amersham were unhappy about what was happening when they went and voted last week in the by-election. Drawing conclusions for the future from these constitutional and political battles that I've outlined isn't straightforward, but I do think some themes can be picked up. First, although some commentators argue that the United Kingdom's unwritten constitution has been broken by Brexit, I think I rather disagree. I think the remarkable feature is how resilient our Westminster Constitution has proved to be under stress. With the government behaving badly because it felt thwarted in achieving its goals, the response by the House of Commons, and particularly its Speaker, the House of Lords, and by the Supreme Court to the challenges thrown up, suggested to me that the checks and balances needed in the parliamentary democracy were in fact still functioning rather well, despite the media froth and sometimes violent language that was being used. That said, there are some worrying signs, to my mind, for our future. The unwritten rules of conduct for the executive and parliament create the trust which is essential for a political community to function, and for minorities to accept majority decisions. When minorities don't accept majority decisions, then you end up with a situation, as you saw in Northern Ireland during the Troubles, usually ends in violence. Those unwritten rules, prevent the abuse of executive power and support the right of opposition, and are one of our country's defining strengths. Over prorogation, those rules were ignored by the Prime Minister, both in the decision itself and by the way in which it was accompanied by an onslaught of disinformation and lies from number 10 that bore more resemblance to the politics of a country sliding into authoritarianism than a stable democracy. But it's right to point out that the principal authors of that disgraceful period have now parted company with the Prime Minister, for which we should all be thankful. So it may just have been a blip during a period of intense political crisis. Another concern is that as a consequence of what's happened, the government is pursuing policies to try to reverse the constitutional clarifications the legal challenges brought in. There's certainly some sign of obsession with the current government over what is termed judicial power. They set up a commission chaired by Lord Folkes on judicial review, which recommended virtually no change because he concluded that no change was needed. But the government is now essentially saying it intends to ignore that and is going to try to legislate to reduce judicial review, although exactly what it intends to do isn't clear. And it may not go very far. But I have a sense, and I do also get the impression that very few people are very interested in it. So it may be that bad ideas will, as usual, be moderated during the process of parliamentary debate. In contrast, Brexit certainly threatens the integrity of the United Kingdom because it's been carried out in disregard of the consequences of devolution. That disregard was clear in the Prime Minister's dishonesty over the consequences of the Northern Ireland Protocol and over the government's handling of the repatriation of powers from Brussels. In fairness to the government, however, when it comes to Scotland, I have little doubt that the First Minister and the SNP would have sought to make use of Brexit to further the cause of nationalism and independence, whatever the government had done. I think the fundamental problem here is that Brexit has exposed a significant difference of view on an issue of core national interest between different parts of the United Kingdom. Don't think we should be surprised about that. Junior partners in a national political enterprise, which is what the United Kingdom is, who have historically accepted the subordination of aspects of their political identity for the benefits of the Union, are less likely to share the obsession with taking back control from the EU, even if nationalists in Scotland have separatist aims of their own. I think predicting how that will play out is impossible. I think I rather share the view of Professor Adam Tompkins, who's a great expert on this. But the one thing we can guarantee is upheaval between Scotland and the rest of the United Kingdom for the next few years, not where it will end up. In Scotland, the economic arguments against independence are overwhelming, seeing that the SNP wants an independent Scotland to rejoin the EU when 60% of its trade is with the rest of the United Kingdom. Its deficit between revenue raised from taxation and its public expenditure is so great that without the subsidy of the Barnett formula, it can't meet EU membership criteria. But politics is not just about economic well-being. My experience is that grievance and identity politics have a dynamic all of their own. What I am sure about in this constitutional is that this constitutional clash has been revived and made more toxic by Brexit when it looked before 2016 that it was slackening. And I think it will produce a series of problems. Northern Ireland undoubtedly contributed to a growth in support for the unification with the Republic. But history shows that any disturbance to a status quo that is accepted by many as the best default position available is fraught with risk. Violence in Northern Ireland during the Troubles came from the actions of a small minority, and the same could happen if a border poll were to be for change. And that change was also wholly rejected by a small minority in the loyalist community. The long-term aspiration of those in Dublin politics for reunification is tempered for many, as I know, and also for many Irish citizens, for neither wanting the cost of paying for it. I think it's about £5,000 per head in subsidy that Northern Ireland is currently costing the United Kingdom, or enforcing it if there is a minority that refuses to accept it. But none of that diminishes the disruption and tension Brexit has caused there. The Northern Ireland Protocol and the problems of its implementation without breaching the spirit and letter of the Belfast Agreement are obvious. It's the very opposite of quiet governance that every government should be seeking to give to its citizens. And that finally really highlights for me the key consequence of Brexit, which was clear throughout all the events which I have touched on. The revolutionary nature of it is because it's not just about our economy. The reduction in trade and commerce with our closest neighbours will, I think, be noticeable in the years to come, and I think we will also see reduced inward investment. And I rather doubt, it's my judgment, it's a matter on which reasonable people may disagree, but I rather doubt that this will be compensated for by deregulation of our financial sector or new trade deals, of which at present there have been hardly any that are not simply replicating the EU's existing ones. But it's more about our world outlook as a nation. We talk about creating global Britain. But for all our aspirations to be involved globally post-Brexit, the evidence of change up to now points the other way. I saw this very much as chair of the Intelligence and Security Committee of Parliament, receiving interlocutors and visiting interlocutors from the Middle East. They would all raise with us their concern at the UK's declining influence, which they dated to Brexit. It's evident in the loss of our seat on the International Court of Justice, where we'd previously always had a judge. It's evident, I'm afraid, I think also in the government's decision to abandon our overseas aid target of 0.7% of GDP, which is very telling in this respect. But I have no doubt that the most alarming for our allies and friends was the clear intention to break international law in the Internal Markets Bill. It's irreconcilable with the government's insistence that our soft power has and will be demonstrated by our reliability in upholding the international rules-based system. A reputation for being reliable and having a stable decision-making processes acquired over many decades is being lost. Of course, it may be recovered as the United Kingdom settles into new post-Brexit relationships, but I think it's going to require a change in attitude in government if this is to happen. And even then, the problem with revolutions is that when their initiators want to stop them, they often find they can't. Thank you very much.
Dominic, thank you very much indeed for a detailed, a superb detailed analysis of the constitutional issues here. Can I just, there's questions coming in that I'll come on to in a moment, but I've got 3 questions immediately that I'd like to put to you. I wondered if any of the 3 Prime Ministers concerned, through Cameron to Boris Johnson, were really familiar with the constitutional intricacies that you have very carefully outlined in your talk. The second question is, obviously, you see this as a revolution because of an attempt to overturn UK constitutional law dating back centuries. Do you think that this is a deliberate and conscious, planned strategy, as it were, or is it just is it unstrategic? Is it a pursuit of a particular aim that where the consequences haven't really been evaluated, haven't really been calculated? It's bull in a china shop kind of stuff. I wondered if you thought it was strategic. I mean, I sort of read a very insightful article at the beginning of last year by Ferdinand Mount about how this was essentially a project to concentrate power in the executive, and I wondered if you saw that as a kind of underlying objective. So, in other words, Brexit is a sort of passage towards something else that is the ultimate ambition. And then the final, third question for me is about devolution. And one of the things that struck me is that you've pointed to the fragility of the relationships and the difficulties and the likelihood of national identity to become sort of problematic to calls for independence. One of we had a talk about this 2 weeks ago, where we had a number of sort of political scientists and lawyers talking about Wales, Northern Ireland, and Scotland. And one of the things that really struck me was the fragility of the kind of union level arrangements, and how easy it was for London to sort of dictate, but also to withdraw, creating tremendous resentment therein. And I wondered if you had any comments about that. So those are 3 questions I'd like to start off with, if that's okay.
Thank you very much. The first one, perhaps the easiest of the 3 to deal with. Start with prime ministers. David Cameron, I don't think, well, it's very difficult to say. I think I must be careful, because in some ways he hasn't spoken for himself entirely about his approach to this. He held the referendum in 2016 because he felt harassed by elements of the Conservative Party who were in favour of Brexit and worried about the growth of UKIP. He was critical of the EU, criticisms which I undoubtedly shared myself. And he wanted to try to bring a resolution of it, and he thought he could win the referendum. The criticism I think that can be made of him is that if you're going to do something, you have to think through the consequences of what it's going to mean for your country if in fact you fail in your aim. And in a sense, he opened Pandora's box, because once the referendum had gone through and it was against him, his own power was finished. He resigned within a few hours of the referendum result coming in. Or I know he left a few weeks later, but he had announced he was gone. And I think that if there had been some proper thinking about what would it mean if the electorate would vote to leave, then some greater thought would have been given to what the constitutional consequences were. And I don't think they'd been thought through. Indeed, my experience of the entire process from 2016 to leaving Parliament and losing my seat standing as an independent in the end of 2019 is that we were really all making it up as we went along. The thing had just not been thought through. So I think we can say that of him. Theresa May, I think Theresa May actually had quite a keen understanding of constitutional issues and propriety. She had her quirks, but I think she was something of a traditionalist in this respect, although she, it's clear to me that the government did not know how we, even after they'd done 6 months' work and triggered Article 50, or 8 months' work, on the day they triggered Article 50, they did not actually understand what the legal mechanisms were for taking us out of the EU, or she wouldn't have got herself into all the problems over Miller. I know a cabinet minister at the time, he said, I don't understand why we're contesting Miller. I have to say, that was my attitude too. Why not just say, well, we think there is a prerogative power, but in this case, we'll do it by statute. It wasn't going to interfere with the government's future ability to invoke the prerogative power because they used a statute in a particular case where they might have used the prerogative power in another. It was a completely unnecessary contest. I've always been mystified by this. I was out of government, but I just didn't understand it. And it was raising temperature where I think it was unnecessary. And it's also quite clear they thought the Withdrawal Act was what they needed to leave the EU. And it turned out as they were passing it that it wasn't. So there are quite a few things. As for the current PM, I have to say that my experience of him over many years is that he has only interest in constitutional issues if he thinks it props up something which is to his advantage. If it isn't, then I don't think he is very interested in it at all. And certainly the evidence of his attitude over prorogation strongly suggests to me that he was utterly cavalier about what he was doing. Leaving aside whether it was lawful or not, it was grossly improper. And it was designed to get him out of a very difficult situation. But another prime minister might have adopted another course of action and thought, well, as I've got this problem, I have to think it differently. In the same way that his ultimate decision to sign the withdrawal agreement with the Northern Ireland Protocol. I refuse to believe that he didn't know what was in the Northern Ireland Protocol, because some of us were jumping up and down on television at the time saying the implications for the future unity of the United Kingdom are really serious if you're a unionist. He just went over to Northern Ireland, had a pint of beer with some unionists and said there will be no border controls. Now, what was he thinking? I don't know. He must have thought and may still think that you can just wriggle out of such an obligation. But my personal view is he was taking a very high risk. And so I don't think he's a person who actually understands the fundamental rules at all. Or if he does, he thinks that they can be ignored when it suits him. Second issue, strategy. No, I don't think it was a planned strategy to cause constitutional chaos. I think the bull in the china shop view is a much better one. Let's be clear, in my own mind and from my own constituents, I'm quite sure that large numbers of people who went and voted to leave the EU in 2016 did it because they wanted a return. They believed the EU had undermined our sovereignty in a way that they found unacceptable, and they genuinely believed that. And they were also persuaded that by leaving the EU, it would be possible to go back to a status quo ante, which they were more comfortable with, and which was, I suppose, encapsulated in those words, taking back control. Now, as I've tried to show in my talk, and I apologize, it was slightly lengthier than it should have been because it's a rather complicated subject. But the reality is that going back to 1971 is impossible because so many other constitutional elements have moved on since. And that in fact, the modern British state doesn't just rest on the principle of parliamentary sovereignty. That is, a government which has a majority in parliament can do anything it likes. It's a much, much more subtle set of rules underpinned by conventions which are unwritten by it but understood, of the way governments behave. And the problems we then had was because as governments came up against entirely predictable obstacles to achieving what they wanted quickly, far from respecting traditional UK constitutional principles, they started to try and find shortcuts to get out of them. And that, of course, then created its own counter-reaction. And you could see it when the Speaker, John Bercow, decided that he would reinterpret the standing orders of the House of Commons. You know, shouts and cries of "this is outrageous," but as the standing orders of the House of Commons are ultimately determined by what a majority of the House of Commons wants, reinterpreting a standing order and then getting it effectively approved by the House when it votes for what the reinterpreted standing order allows is arguably entirely compatible with the principles of parliamentary democracy and parliamentary sovereignty that they were claiming they were bringing back. So yes, we've had a lot of hot air and some squabbling. But as I also tried to say, I think for all that, the UK constitution has emerged largely intact, although there are still people who still seem to believe that there are other things that they ought to do to it as a consequence, which I think would be much more damaging. Devolution. Devolution has been problematic because I'm afraid that Tony Blair did not think through the consequences when he promoted it in the 1990s. It may have been thought to be a good idea, but Blair seemed to have misunderstood the extent to which the shift of power was in fact significant, particularly with Scotland. I think Wales and Northern Ireland are slightly different, although Wales now has primary legislative power. But with Northern Ireland, Scotland, the shift in power was obvious and very considerable. And yet I think he memorably said that, oh, the devolution administrations are no different from local government. Well, he was wrong. And the problem was that not only was he wrong about that, but having got it wrong, he then tried to govern throughout the United Kingdom, helped by the fact he had Labour administrations in every part except Northern Ireland, in exactly the same way as the old Soviet Union managed the stans, which is to say you picked up a telephone and you told your Labour Party counterpart, who you also knew through national politics in Edinburgh, and you reached an agreement with him. So we never put in, when the opportunity arose, the real mechanisms for intergovernmental working, which devolution requires. So there's a fundamental lack of trust. And increasingly, as the Scottish civil service has arguably gone native, even the relationships between the civil servants have started to change. So there is a real problem. And I don't think it was an unmanageable problem. Indeed, my argument when we went into coalition in 2010 was that the Conservative government had a golden opportunity to try and put it on a new footing. And I think we could have done it post the Scottish independence referendum in 2014 if it hadn't been immediately superseded by the Brexit referendum, where the Scots articulated and have articulated since a deep grievance about the way they're being treated. And whilst you can argue that in the United Kingdom, that's just how it is, you can't get away from the identity politics which it has helped create. And from that point of view, we do now have, I think, a very serious national crisis about our future identity. And of course, if Scotland were to part from us, it is the end of the United Kingdom. We will be England and Wales, or possibly England, Wales, and Northern Ireland, but it is not the United Kingdom that was created of Great Britain that dates from 1707. The international consequences will be massive. Our seat on the Security Council, I think, would be put in question. Our ability to conduct our national defence as a key partner in NATO would certainly be endangered because Scotland is strategically critical to the United Kingdom. And the humiliation of it would be very considerable. Now, whether it will happen or not, I don't know. sometimes argue that it's more likely to happen because the English decided they'd just get rid of the Scots than the other way round. But it's not a place where I, as a unionist, and after all, I've been a conservative and a unionist all my life, wish to be. And that, to my mind, is the single most serious threat that we've got. And it's interwoven with Northern Ireland. Wales is slightly different for a variety of reasons. But that is the biggest consequence of Brexit and its unresolved issue, without saying which way it will ultimately pan out.
Great, thanks very much. We've had a number of questions in, and I'm just going to sort of summarise them. I mean, there's sort of a reflection of the division that exists in the country, the polar opposites, the Utopia, Dystopia. There's one which just says Boris won. That's it. We should just accept it. We're out. Let's just leave it at that. And besides, he's responsive to voters in a way that David Cameron and the elitist side that he represented never were. So that's one opinion. The second opinion is from sort of other side of the spectrum, if you like, from David Patey, who asked two questions. The first is, where do we go now? How long will it be before the UK returns to the EU? But he wonders also whether there was an inevitability about the referendum, whether the way that the internal politics within both parties, the Labour Party and the Conservative Party, or both main parties I should say, but both governing parties, played out, that some kind of showdown was inevitable, and this is we're sort of living through the results of that. Two more questions, if I may. Rupert Reed asks, was there a possibility, do you think, in the autumn of 2019 of creating an alternative government? Was there an alternative majority in the House of Commons? And then the final question, Katie notes that you've mentioned propriety several times in your talk. Do you think propriety or disregard for propriety are the root cause for many of the issues you've spoken about, and what can be done to correct this?
Thank you. Some big questions. I shall try and deal with each in turn. I think I can possibly take one and two together, because I think that they are, in a sense, mirror images of each other. Say the first thing, I don't see any possibility of our rejoining the European Union anytime soon. Whether we might do so at some point in the future, I simply don't know. My reason for saying that is simple. The United Kingdom had, in the course of its many years of membership of the EU, EEC and EU, carved out a very particular niche for itself that respected many aspects of what I think might be regarded as British exceptionalism. We had opt-outs from a number of EU policies, most significant of which was not joining the single currency, which I'm absolutely right in my view that we shouldn't have done so. And we had a significant rebate, which had been negotiated by Mrs. Thatcher. I find it impossible to see how we would ever be able to rejoin with those British bits of exceptionalism accepted by our EU partners. Indeed, I think rationally, they would probably say, I know Denmark has some one or two similar things. I think that rationally, they would say, well, if you're going to go back in, you would have to sign up to the total package. And after all, I was very pleased that we didn't have the total package, and it enabled the UK both to have influence and leverage in the EU of a very considerable character, and the protection of the participation in the single market, which I believe to have been immeasurably beneficial to us economically. And I'm old enough to remember what was happening to Britain before we went into the EEC, and how we were failing economically in comparison with our EU or EEC partners of the six. So I think that going back in, it could happen, but it would require a very significant change in public opinion, even beyond what I would call the Remain-Leave split in 2016. Now, Linked to that, in the second question, is about what would have happened if we'd done nothing. Well, I'm afraid I think that if the Prime Minister, David Cameron, had simply tried occasionally to negotiate, kept his ground, it is possible that UKIP would have done better in the 2015 election. But the demographic evidence of age profile suggests, and I mean, this is the ultimate irony, that on the basis of who believed or believed passionately in leaving the EU and who was very content with remaining in the EU and trying to exercise influence within it, that those seeking to take us out of the EU were in fact a group who were reducing in numbers by age, progressively. And as this is something that had been going on for some time, was likely to lead in a 10 to 15 year period unless something dramatically went wrong with the EU, so people's opinion changed markedly, to the numbers wanting to leave being lower than the numbers wanting to remain. David Cameron was, I think, unlucky that he picked his moment to have his referendum at a time when the EU had come in for some very proper criticism, but also there was a very significant malaise amongst the public about the consequences of the 2008 financial crash, which in many ways are still with us even today in Western Europe and have not been fully resolved. So I personally think that we would still be in the EU today. And I actually think that every passing year would see more and more people seeing it as not that they were wholly happy with the EU, because I've never been wholly happy with it, but would see it as Britain's best place to exercise influence and promote itself and its own well-being. Your first interlocutor also said we've just got to accept it. Well, as I just said, it's not a question of whether you accept it or not. I think, if I may be forgiven for putting ideas into his own head, what he's saying is I should be cheerful about it, and I'm afraid I'm not. And I think he's going to find that there are a very large number of people in this country who are not cheerful about it. And indeed, I detect from the Chesham and Amersham by-election result that in the wealth-producing parts of the United Kingdom, their core wealth-producing areas outside of London, the discontent with the Prime Minister, his chaotic style of government, and his dishonesty is growing. Now, these actually don't have a huge amount to do with Brexit. It's true that he came to power because of Brexit. Indeed, you could argue that the Conservative Party created him because they were so frightened of the consequences of Brexit. They wanted him as leader to get them out of their hole. But 18 months down, or 2 years down the track, virtually, since he became leader and prime minister, I detect amongst core Conservative voters in the southeast of the sort who propped up my association that they are really unhappy with him. Now, it may be a blip or it may be permanent, but my feeling is I think that this is a fundamental reappraisal of him. Now, that's not to say that if he were to go, he won't be replaced by somebody. He's not going to be replaced by somebody in the Conservative Party who's going to say we're rejoining the EU tomorrow. But I do think that as time goes by, there is going to be a public debate of where does the United Kingdom's best trading interests lie, because this is about the economy. And my view is that it is inevitably going to lie with our neighbours. Similarly, our security is totally bound up with that of the security of our neighbours. And they're not going to go away, they are there. I don't think the United Kingdom is about to be hauled 2,000 miles into the central, or was it 10,000 miles into the Central Pacific anytime soon. And therefore, all this business of trans-Pacific partnerships is, I'm afraid, a fantasy. And I think we're going to find that the reality is we're going to have closer working relationships with our European partners, but probably conducted outside. Third question. Autumn, and I will have to ask somebody to remind me of the fourth. Autumn of 2019, did I think it was possible that we could get some government of national unity? Well, I hope I'm a realist. I didn't set out post-2016 to end my political career by having to stand as an independent in the 2019 election and lose my seat, even though when I stood as an independent, I knew very well that my chances of winning were very, very low. But I thought it was worth doing because I thought there was an argument to be made. And I also thought my constituents could make their own choice rather than me simply saying I'm sliding off, thank you very much. And it was the party, after all, that had withdrawn the whip. I used to say to myself on a daily basis, don't do anything because you're angry, do anything if you think it might be constructive. And I did take the view that having a second referendum might be constructive for two reasons. One, I hoped it might be possible to get the initial decision reversed because I thought that by 2019, we were facing something which was markedly different from what was being offered in the 2016 referendum. So I didn't think it was improper to go back to the electorate and ask them to confirm that this is what they wanted. I know that attracted a huge amount of abuse to me, but I still thought it was the right thing to do. Secondly, I also accepted that it was possible that if we had such a choice, that actually we would find that the electorate said, no, we're totally happy with this. Please let us, we're going. In which case it would actually have been quite healing, I think, for bringing people together subsequently and more accepting of the decision. Did I think it could be delivered? Well, it could only be delivered in two ways. One was the possibility that if Boris Johnson realised he couldn't take us out with no deal, which I do believe was his intention. He wanted a deal, but he was prepared to do it in September and October 19. I'm absolutely sure of it from lots of things I heard. And that, of course, was when we had the critical majority of enough conservative rebels willing to work together to stop it, even though some wanted a soft Brexit and some, like me, wanted a second referendum. It was therefore possible that if he was prevented from doing it, he might just decide that a second referendum was a better way out, because I think he's an opportunist, and actually I think he's quite pragmatic in some ways. Failing that, the only way you could get it was either that bill have a government of national unity. Now, that wasn't completely impossible in my judgment, but it required Labour to part company with Corbyn, because it was obvious that Corbyn could not lead a government of national unity, because he was regarded as being so rebarbative by a significant section of the centre and right of centre electorate because of his agendas, other agendas. And I must say, I think it was possible, but it was always quite a slim chance. It would have needed Corbyn to be essentially, well, actually his power base to collapse, people to say that they were prepared to have a government led by Yvette Cooper or Keir Starmer, or might have been Hilary Benn for that matter, simply for the purpose of delivering a second referendum. It was talked about. There were undoubtedly Labour MPs who were in fact willing to do it. I would have been willing to do it in order to bring that second referendum about. The third option was clearly to have a general election, and that's what we ended up having. The difficulty with that, and I accept it delivered a verdict, and it undoubtedly gave Boris Johnson the mandate he wanted to bring things to a conclusion. But the problem was, from my point of view, others will disagree, that the election, although Brexit was in the background, was also about who do you want in Downing Street, Boris Johnson or Jeremy Corbyn? And for a big swathe of Middle England, there could only be one answer to that question. Even though I found on the doorstep that there were plenty of people who said to me, I'm really very unhappy with Mr. Johnson, but I think I'll give him the benefit of the doubt. We had plenty of that. Ultimately, the threat of Jeremy Corbyn being in Downing Street was quite enough to ensure that very large numbers of people decided that it was in their best interest to vote Conservative, whatever their reservations might be about Brexit or about the Prime Minister. Now, there was also a fourth question that I've forgotten about, but you can remind me, Hussein, what it was.
It was about propriety and what do we do to restore propriety in public life and politics?
It's a matter about individuals. You have propriety because you have a self-reinforcing group of people, mutually reinforcing group of people who insist that people should behave in a proper way. Proper being within certain ground rules, often which are not written down, and that they don't seek to get round the rules and they don't seem to get round the written rules. The problem is once you get leadership, which is really unconcerned with propriety, then it starts to reduce everybody else progressively to the denominator of the leader. Now, I'm very conscious, I've been very outspoken about the present Prime Minister, somebody I don't know very well, but have known for many years, who is very engaging, very charming, and undoubtedly has winning ways with sections of the electorate. But I'm afraid my own assessment of him is that he is fundamentally flawed. He's the man who appears to be incapable of distinguishing between truth and falsehood. And whilst politics is in part about black arts, and many politicians end up having to say half-truths, I don't think I've ever come across somebody who is such a brazen liar and very, very persuasive at doing it. Now, that has consequences. You can see it over the question of the decoration of his flat. In a way, it's a sideline, but it is rather telling. On the whole, there are rules in place to protect ministers from any suggestion of undue influence, which might be disreputable. But the conduct of this government over its procurement policies under COVID is, by modern British standards, incredible. I can't think of anything else quite like it. Well, I know there are sometimes other allegations. We had them under Labour and other Conservative governments, of ministers being subject to undue influence, which is of an improper character. But this government just gives the impression it doesn't care. And maybe the electorate doesn't care, because the electorate concludes, oh, well, all these politicians are all thoroughly flawed and dishonest, so what's new? Well, I think there is something new. I think there's something very new in our politics at the moment, which I have never seen before, and which makes me very troubled about the future. And perhaps we should be equally troubled about that as about policy issues.
I was thinking about the sort of just sort of extending this a bit, the sort of the monstering of journalists. I mean, and politicians we've seen recently, that particular case of FT journalists being threatened. Well, we're approaching 8 o'clock. There's another cultural event happening at 8 o'clock as well. I'm sure
there is. Yes, I'm sure. Which in competition with me, I think it probably relegates me to the sidelines.
Well,
I'm happy to do any more questions if you want me to do a couple more quick ones. Up to you.
I must say I haven't got anything else coming in.
Right.
It's our final event. So before thanking our speaker, can I just thank everybody who's come to this event and others before, virtual though it's been. Let's hope the next year, the next series can be resumed face-to-face. If you've missed any of the previous talks, you can a link will be circulated and you'll be able to find videos and audio recordings. And if you continue to be interested in Brexit, could you consider following the UK and changing Europe, or Negotiating the Future, both of which provide expert and independent analysis of UK-EU relations. So that's UK and Changing Europe and or Negotiating the Future, which I must say is my project. But Dominic, thank you so much for that detailed forensic analysis of the Constitution. I'm sure many people have never heard that before, and so it's fantastic that you should come and talk to us about it. So
that's a pleasure. I hope it was comprehensible. One of the problems with lawyers is that unless we make it comprehensible, we're not doing our job. But I hope we've succeeded in doing that.
Understood. So thank you so much.
Thank you very much.
Thank you. And there's going to be a very abrupt end to this, because that's the only way that you can end virtual events. So we're going to be cut off ruthlessly and brutally.
Thank you very much.
Okay, thank you.
Good night, all.
Thank you. Good night.
Good night.